Thanks for joining us here on 9 News Plus. I'm Chris Bianchi here with 9 News legal expert Whitney Traylor. We're going to discuss the Supreme Court, which is hearing oral arguments in the case of a Colorado web designer's claim that she has a right not to serve same-sex couples under the First Amendment. It is a free speech versus discrimination sort of case. And Whitney, this is obviously getting big national headlines as well. Can you start off by just telling us about this case and the background of it?
Right. So this case is interesting because this is a website developer who's seeking to expand into the wedding industry. So she actually hasn't refused service to anyone, but she sort of preemptively filed this lawsuit to determine whether or not she could actually do so. So what the parties did was they agreed on sort of a mock-up website that she would use, and they agreed on certain facts, and then they went forward on those assumed facts. And that's not unusual for the court to do so in order to sort of have the case presented to the court. And so what she's saying is, hey, in Colorado, we have this anti-discrimination law that says you have to, in public accommodation, you have to provide service to everybody regardless of sexual orientation. So if you provide a service to the public, you can't deny people based on sexual orientation and other things like that. So what she's saying is, hey, if I expand into the wedding industry and start doing websites, that's my artistic expression, that's my First Amendment, right to, endorse whoever I'm providing a website for. And she said, I don't have any issue with, homosexual folks or same-sex, but she said, but same-sex marriage is the issue. That's my religious belief. And so by doing a website, I would be endorsing that. They would be compelling me to speak. And so she's arguing a First Amendment violation. And so that's what the court is really trying to decide. Is this her free speech, and does she have a right to not speak this, or is this just sort of a run-of-the-mill website and she's not providing a message?
I know with these Supreme Court cases we can often glean where they may be leaning based off the questions they're asking. Do we have that in this case?
Well, there were a lot of questions, and this case was really interesting because the court threw all these hypotheticals out there, like, well, what if there was a black Santa and a kid came in a KKK suit and the black Santa refused to take pictures? Or what if there was a Jewish and a non-Jewish person seeking to get married and they said, hey, we don't want to do that? So the court went through a bunch of hypotheticals. And I think a lot of scholars are saying that, with this conservative, we have a 6-3 conservative court, that they are going to lean towards ruling in favor of the web designer. We'll know probably in June of next year when they issue an opinion.
Those same scholars, what's the general legal opinion of the validity of this case? We'll break it down a bit more in just a second, but what's the overall feeling on this?
Well, it's going to be a question of whether or not this is this an expression? Is this an artistic expression? And the question is, or is a website sort of a standard? You just, present, you just plug in the couple and everything else is standard. And that's really the argument. Is this individual enough to the website designer that each website she designs is sort of this individual artistic expression? And that's really what it comes down to. And it is a legitimate issue in the sense of, if you have somebody with these sincerely held religious beliefs, right, and they say, I believe a marriage should be between a man and a woman, the question is, are they endorsing a same-sex marriage by providing a website or by providing a cake, right? And on the other hand, the argument is, well, it shouldn't even have to be a law. This should just be a moral thing that we're going to serve one another if we're open to the public. But notwithstanding that, it is the law in Colorado. We have a public accommodation law that says you can't discriminate based on race or national origin or sexual orientation. And so that's really the question. Is this law going to supersede her right to deny service? And as you may remember, we had this in the 2018 Masterpiece Cake case. And in that case, it went to the Supreme Court, and it was essentially the same issue, but the Supreme Court ruled in a very narrow way, saying that, ruling for the baker, but saying that Colorado basically didn't treat him fairly. So they didn't answer any of the questions about whether or not, somebody can deny this kind of service. So everyone was expecting that in the 2018 decision, and that didn't happen. They essentially punted. And so now that question is probably going to be answered in this case.
Could they rule narrowly in this case as well?
They definitely could rule narrowly, but I don't think these justices will do so. And, and that really raises the question, if they do rule in favor of the website developer, does that mean people can now start refusing service on other things related to race or national origin or all these other things?
I mean, again, I don't mean to inflect my opinion at all on this. The first thing that comes to mind is, if you do rule in favor in that case, does that not open this huge can of worms of saying, well, my religious beliefs say that Jewish or black people or whatever are inferior. I'm just saying that hypothetically. Couldn't that open this potentially kind of horrific can of worms, couldn't it?
Well, it absolutely could, and you have to go back to the 1950s and 60s, and primarily the 60s, when we started to have anti-discrimination laws. And I remember reading, like when they were debating Title VII of the Civil Rights Act of 1964, and there was a senator who on the Senate floor said, hey, I want the right to discriminate against people I have to serve, and I want the right to be discriminated against. And in essence, they were saying, hey man, businesses, it's private business, you should be able to serve or not serve whoever you want. But obviously during the 60s, when we're pushing for civil rights, that didn't work, and they essentially passed Title VII to say, you can't discriminate in employment based on these certain things. You can't discriminate in who you're accommodating based on these certain things. So the laws have been developed over many decades to protect people from being discriminated against based on these certain characteristics that they were born with, their skin color, their gender, some of those things. And so this will open the door for more challenges, for sure. I don't think those rights will be chipped away, but that's what they're concerned about with potential, same-sex marriage, which we have the new law that President Biden just signed.
Yep.
I mean, so a lot of states, these rights are being chipped away. You're looking at the abortion rights, and states like Colorado implemented a state statute protecting that right. So it's interesting how you're seeing the legislative branches of government get involved to legislate, where they're seeing the Supreme Court chipping away at some of these rights.
I guess I got a couple other questions. One, is there a definition for where the limit of free speech goes in this case? Where is that intersection where free speech, and you mentioned Title VII, where do those meet? What is the current federal and state definition of that?
Well, and it's really interesting because all of our amendments, the Bill of Rights, they all have exceptions, right? We hear a lot of argument around the Second Amendment, and folks say, don't infringe on that at all. But all of the amendments have exceptions. So, for example, the First Amendment, right to, among other things, press, assembly, speech, and all these things. But when you have a freedom of speech, that's not unabated. So, for example, you can't, if you're likely to incite lawlessness, they can regulate commercial speech. So when you have, for example, the adult entertainment industry can only advertise during certain times of the day, right? They're regulating them in that way.
Well, the reason you can't start cursing right now, there's right
the FCC, right? So there's a lot of ways that obscene and immoral. And there's a whole test that the court came up with to determine whether speech is immoral or obscene. And so that is a very somewhat ambiguous.
It's tough.
Yes, it's an ambiguous situation. And here the question is not only, where do the rights kind of meet, but the question is this even speech? Right? And so, for example, if you're creating a website and it's just a custom website, you just have a template for all of and you just change the colors and they give you the text and you put it in, right? is that your individual speech? Right, and this is what some of the justices asked. Well, the caterer or the person who comes to set up the chairs or the decorator for the wedding, are they also now artistically expressing themselves? Because if they are, then that is going to be a situation going forward that everybody can say that. You know, both this is my freedom of speech, and they can claim the religious aspect and say, for example, you know, my religion doesn't believe in interracial marriage, and therefore deny it on those grounds. So I think you're going to see more of those kind of cases going forward. And when we look at all the cases together, we'll have a body of law, and we'll have some precedent. So this is the first of many, regardless how the Supreme Court rules.
I guess with the plaintiffs, I can't imagine that they're going to actively be saying we want to discriminate. So what is their argument in terms of saying, well, we want free speech, but we don't want to discriminate? How do they define that?
Well, and this is what she said. She said, that's fine if, you know, people are homosexual or whatever, but she said, my religious beliefs are that marriage is between a man and a woman. So by forcing me to make this website, you're forcing me to endorse that. You're compelling my speech is their argument. And so they're saying, you know, I shouldn't have to be forced to go against my religion to stay in business. So it's, you know, regardless of my individual beliefs, from a legal perspective, there's arguments on both sides.
Again, without inflecting too much of my own opinion, couldn't the defense come back and say, look, I'm staying in front of you, I'm staying in front of the camera, I have a, you know, maybe I have a desire to curse or whatever, but I know within my line of work, I can't do certain things. You kind of give up certain rights for private employment or to serve people.
Right.
I just, to me, off the top of my head, doesn't it seem, I don't know, it just seems
Intuitive,
like
no, I think you're exactly right. Like the spirit, you're getting at the spirit of the law, right? There's the technical law, there's the meaning of the law, and then there's the spirit of the law. And the spirit of the law is that, no, we're not going to be a society that says, I'm not going to serve you, you know, for this reason or that reason if you're open to the public. And so I think what you were getting at, your sort of intuition, is that, well, wait a second, if people can start, you know, when you go into business, this is what you do. When you go into a public service, you know, when you're serving the public, you can't pick and choose.
Find another line of work, right? Would that not be the sorry, like, I mean,
right,
you got to abide by the law.
And that's, you know, and honestly, I did employment discrimination. I was a civil rights lawyer for, you know, almost 30 years. And I saw case after case like this. And we won nearly every trial we had in 25 years, where we were representing employees or potential employees where the employer said, no, we don't want to hire any brown people. Or, you know, women shouldn't be in leadership positions. You know, they're too emotional. These are actual things from cases. And so it's sort of like those are, right, this kind of thing still happens, notwithstanding the law. So I guess what I'm picking up from your energy is sort of like, well, this is just sort of the right thing to do when but people are still, this is why there's still lawsuits, because people are still trying to get around the law, trying to, you know, only employ or work with people who look like them. And that's not the law. That is unlawful.
I mean, I guess the reason I say that, and again, I'm just listening to what you're saying and the arguments from both sides, is that the potential can of worms that something like that could open up, you know, what is a religion, for example? You know, I have, you know, it's not necessarily Christianity, Judeo-Christianity. It could be, I have my own religion that believes all these weird, funky things. You're getting into such a weird ground, am I right, that it could open this can of worms that everything's on the table and not in a good way, potentially.
Right. No, it's a great point, and this has actually been an issue that's also been litigated. Is this, in the legal standard, is a sincerely held belief? Because remember, employers also have to accommodate people's religions. So if people have to pray a certain amount of times a day, or can't work on certain days, or any of these other things, the court has a whole body of law to decide, hey, is this actually religion? Is this a sincerely held belief? And in fact, the court has even said atheism is treated as a religion. Your belief that there is no God, right? And so even, for example, atheists, if the company said, we're going to pray before work, and the atheist said, no, they also have protections in that regard. So it is a very fluid situation, but that's how our kind of common law system of case law works. We develop precedent, new cases with new facts come up, and we start to shape the case law.
Fascinating indeed, and we'll find out in June, right?
Yes, that's when they're expecting, the opinion. Mm-hmm.
All right, so we'll find out in June. Again, defining some of these gray areas right now. There's no doubt about that. So, Whitney, thanks for offering us your insight about this interesting case, and I suppose we'll find out in a few months.
Yeah, and there'll be more. I mean, there's so many cases that are going, that are in state court now, that are at various levels of appeal. So this is just going to be one of many cases. But with the conservative court, most people are saying they're probably going to rule in a more conservative way. And if they do, then you'll see more cases where people are rejecting providing service because of sexual orientation, interracial marriage, interfaith marriage, all these other things. And you're going to see the courts have to deal with that.
Interesting. So we'll find out coming months and years. But
Yes.
Whitney Traylor, thanks as always for your time.
For sure. Good to be here.